Hello, good evening and welcome. I'm Karima Brown and you're watching Political Exchange, where we unpack Africa's political economy. Tonight my guest is international criminal lawyer Nick Culfman. He of course is the lawyer of some of the most well-known individuals both in politics and business who often appear in international fora and institutions such as the International Criminal Court. Mr. Culfman is in Johannesburg representing a Zimbabwean businessman who has appeared on the Interpol Most Wanted list, and he joins us now tonight as my guest on Political Exchange. Mr. Culfman, thank you so much for joining us here on Political Exchange. Take us through what brings you to Johannesburg. I understand the case or the client that you're defending is a Zimbabwean businessman who found himself on an Interpol Most Wanted list, unable to travel to his business. You've got the who's who in the world and certainly in Africa on your client list, from members of the Gaddafi family to Imelda Marcos. Take us through the case that you're in South Africa for right now.
Well, I was invited here by Mr. Buyanga, who has been made essentially a victim of the Zimbabwe justice system. Mr. Buyanga was operating a very successful property acquisition business in Zimbabwe and unfortunately came into contact with one of the officials in the Zimbabwe government who made a loan to. After making that loan, he suddenly found himself subject to a reinitiated criminal investigation. And soon thereafter to an Interpol red notice. I should stress that this criminal investigation was an ongoing criminal investigation which was initiated as a result of disgruntled customers back in 2010, and the chief super-inspector at the time, Chikandiwa, who had investigated the case, declared on oath to the Harare High Court that the case lacked any criminal essence to it, and he had closed the criminal investigation.
So how does your client appear on the Interpol list?
Well, what happened was that 2 years later, after the loan arrangement with the minister in Zimbabwe, he suddenly found himself subjected to an arrest warrant. And that arrest warrant apparently is the basis for the international red notice, the Interpol red notice. The effect of this essentially is that Mr. Buyanga cannot travel around the world without the threat of being detained at a port of entry and then perhaps made subject to extradition proceedings if the country to which he's travelled has an extradition agreement with Zimbabwe.
Now, of course, the question of regulating international travel as it relates to questions of sovereignty, issues of criminality, very key figures moving across borders is something that is very much part of the current kind of global, governance structures. You've been a prosecutor at the International Criminal Court at The Hague. You now defend clients who have to appear in front of this court. Take us through the procedures of the ICC as it relates to the laying of charges, what prosecutors have to look for, and then of course also the kinds of ways in which people have the right to defend themselves. Mm-hmm. And essentially what I want to get to, Mr. Culfman, is do you think the ICC has legitimacy, and do you think that people get fair representation in institutions like that?
Well, you've asked a whole load of questions, and I could speak all day about the fairness of proceedings at the ICC. Let's take the specific issue of travel. Don't forget that the ICC is a court. It has a prosecutor who analyses whether or not there is evidence to put an individual on trial, but it operates according to evidence, and only when there is sufficient evidence to warrant a prosecution does the prosecutor then go before the court and ask for an arrest warrant. Mm-hmm. Interpol, and should take another example, the United Nations sanctions committees, the various sanctions committees set up in various conflict zones around the world, don't operate always on the basis of evidence. Mm-hmm. They operate on the basis of intelligence information, which is often supplied by an interested state party. Now, coming back to the ICC, right, after an arrest warrant has been submitted and perhaps requested and then granted, an individual has a right to defence counsel and he can challenge the evidence. Mm-hmm. That's unfortunately not so much the case at Interpol or before the United Nations sanctions committees, where often a lawyer who's representing a client is subjected to a restrictive measure, whether it be a travel ban or whether it be a
Freezing
red
of
notice
assets.
or whether it may be freezing of assets, he's not entitled to any information. There is no transparency. There's no right of appeal afterwards. All he can do is make his submissions and, as it were, shoot in the dark. That's the distinction between the various supranational, should we say, regulatory bodies such as Interpol and the United Nations Sanctions Committees and the ICC. Now, the question of whether or not the ICC is a fair and just institution, well, it is, for all intents and purposes, a court which has been set up as the result of a multi-state party agreement. It's not a United Nations court. That's the important thing to stress here. It was set up by the state parties, and the state parties who are, of course, signatories to that court. There are a number of state parties
who are not signatories,
and most notably the state parties or the states where conflicts are ongoing or are involved in conflicts. The United States, for example, is not a member of the International Criminal Court, nor is Russia, nor is China, nor is Israel. So to say, is it a fair institution? Well, you have to ask the people who asked for this institution to be set up. Now, the major criticism which has been levelled at the International Criminal Court is that it is too Africa-centric.
Yes,
and
yes.
that it's
in
taken
fact,
too much of an interest in Africa.
Let's park there, because the latest or the most well-known cases that are in front of the ICC now, of course, is the kind of major players in the Kenyan political elite. In fact, Uhuru Kenyatta, the recent candidate that was victorious in the Kenyan elections, is in fact indicted at the ICC, Mr. Ruto as well. You have had dealings with these individuals. I've spoken certainly to a number of Kenyans who believe, as you pointed out, that the criticism is that the ICC is too Africa-centric, and given the fact that so many of the parties that are not signatories to this court, their political and strategic interests are tied up on a continent like Africa, that these institutions are being used as political instruments. In the Kenyan example, from what you know, would you say such a charge is a fair one?
Well, Kenya is a bit of a special case because, unlike the other African situations which are currently on the docket of the International Criminal Court, the Kenyan situation was really forced upon Kenya as a result of prosecutors' proprio motu. The same is also for the Côte d'Ivoire as well, the situation there. But an investigation was conducted by initiated, shall we say, by the former prosecutor of the International Criminal Court, Mr. Luis Moreno Campo. He targeted his investigations against, for all intents and purposes, the Uhuru Kenyatta. He has now won the elections. That is the democratically expressed wish of the Kenyan people, whether you like it or whether you don't. I think Mr. President Kenyatta has stated that Kenya intends to honour its obligations to the International Criminal Court. But yes, there has been a lot of criticism, and perhaps rightly so, because of the witnesses that the prosecution have been selected. And this is not just the Kenyan people's criticism of the International Criminal Court. It's also the court's criticism. The court has been scathing in its criticism of the office of the prosecutor, in its modes of interviewing witnesses, in its modes of disclosure of evidence. And in fact, it has been stated that one of the judges, a very well-known Belgian judge, a very serious academic in the field of international humanitarian law, Judge Christine van der Wiegert, has asked to be excused from the case as a result of the behaviour of the office of the prosecutor. Whether or not that's the case, I don't know, I'm not sure. But the fact that a judge has asked to be excused from a case is in itself a significant matter.
Mr. Culfman, from where you're sitting, do you think that the case against the Kenyan president has no foundation? We know that one of the 4 people attached to the case has actually been dismissed for lack of evidence. Do you think we're going to go the same route here?
From what I know of the case, and of course I'm not privy to any of the evidence against President Kenyatta, but from what I've managed to gather from reading the materials surrounding the case, I think that the case is basically built on legs of straw. I think the case is going to fall apart sooner or later, yes, unfortunately. Yeah.
Now, if
for international justice, but not necessarily for President Kenyatta. I don't think that on the basis of what I've read, that the charges really are made out against him. It seems highly bizarre, the nature of the charges against him. And furthermore, the way that these charges have been investigated don't seem to be, to me at any rate, have been the most, doesn't seem to me that the most professional methodology has been employed.
Now, it's interesting that you highlighting the shortcomings of the operations of the prosecutor. You yourself was a prosecutor at the ICC.
That's correct.
What do you think happened in the Kenyan case? And as a former prosecutor, what is the mechanisms that the institution has to ensure that prosecutors do not abuse their position and actually, comply with the rules of evidence that ought to be there, that lays the foundation of whether someone is going to get a fair trial or whether even the basis of the charges are legitimate to begin with?
Well, I think here in the Kenyan situation, there's a matter of personality involved. The present prosecutor, Fatou Bensouda, is a completely different character from the former prosecutor. The former prosecutor was an extremely flamboyant individual. His control of the English language was particularly poor, which unfortunately is a serious disadvantage for a prosecutor. Appearing in front of a tribunal where the main languages are English and French, his handling of the cross-examination of Uhuru Kenyatta in the confirmation proceedings was very amateurish, and the sort of questions which were asked were completely below the belt. Questions as to President Kenyatta's finances. And they were asked in a very poor fashion questions, well, the charges were confirmed, but then, as I said, serious criticism has been levelled at the methodology employed by the Office of the Prosecutor to investigate the case. That criticism has to lay at the former prosecutor's door. Now, Fatou Bensouda has inherited that case, and she's a different character entirely, far less publicity-seeking, far more, shall we say, acceptable to the African community in the sense that she herself is an African. It's harder to level against her the same sort of criticisms which were levelled at the former prosecutor.
And do you think the fact that she is African and the fact that she is not seen to be grandstanding, if you like, that would lead to a more granular and more thorough approach, whatever the outcome of the case against Mr. Kenyatta?
Well, my personal knowledge of the present prosecutor is that she is a very thorough individual, and that she has a very professional take on international justice. And yes, I do think that there's definitely a change for the better. What the results and the outcome will be in the Kenya case, one can only know. But one has to admit and acknowledge the fact that when it was found that evidence no longer existed against Francis Mutara, the person who was formerly co-accused of President Kenyatta, she had the decency to go before the court and to initiate the withdrawal of the charges. Now, that is something for which a prosecutor has to be credited. Maybe she will sooner or later come before the court and say that the charges against President Uhuru Kenyatta can no longer stand.